Spoken like a true minister.
Yeah.
Question is that this bill be now agreed to in principle.
You can speak on this side with the national,
I call the member for Balmain.
You never know your luck.
John, don't be like that.
You never know your luck. Thank you very much, Mr Temporary Speaker. I rise today to speak on behalf of the Greens for the Births, Deaths and Marriages Registration Amendment, Change of Name Bill 2011. We will be supporting this bill, and we've got a cheer over there.
Look at that.
A cheer from the House. And I will just spend briefly the amount of time I have today talking a little bit about the bill, but also highlighting the concern that was generated in the community by this proposition that criminals could change their name willy-nilly, when in fact the opposite is true. And while we support this legislation, there's clearly provision to refuse name changes, which I'll mention briefly. So this bill defines a class of restricted persons who may not change their names without obtaining written approval from their supervising authority. The supervising authorities are required to notify the Registrar of Births, Deaths and Marriages of all restricted persons. There is a penalty for making an application to change a name directly to the Registrar rather than to the supervisory authority. Proposed Section 31B defines restricted persons to mean inmates of correctional centres, persons on remand in correctional centres, persons that are subject to certain supervision orders made by a court but are not in custody, persons on parole, periodic detainees, forensic patients and correctional patients. For a change of name of a former, quote, serious offender, end quote, the Registrar must get written approval of the Commissioner of Corrective Services and the Commissioner of Police unless you have been out of prison without reoffending for 10 plus years, which was a question that was raised in a previous speaker. It's important to note that serious offenders currently comprise around 7% of the New South Wales inmate population, and they include those who are serving a sentence for murder and or who are serving a sentence for life, serving a sentence with a non-parole period, who will not be eligible for release until they have spent at least 12 years in custody, and that deemed to require being managed as a serious offender by the sentencing court, the parole authority or by the Commissioner. And we look forward to the new Attorney General to do his best to reduce recidivism and make sure that we have safer communities and a smaller prison population. The intention is to remove circumstances in which offenders change their names while in custody and Corrective Services is not currently even aware of the change. This makes it both harder to monitor these people and can also be done for the improper purpose like furthering unlawful activity. For instance, and of course we support this measure in order to mitigate against those improper purposes. Now the current Act, Section 29A of the Act, contains a requirement to disclose any conviction of an offence. Conviction of an offence is defined broadly and includes a Section 10 under Section 10 of the Crime Sentencing Procedure Act 1999, but does not include a spent conviction. It applies where the relevant offence is punishable by 12 months or more if committed in New South Wales. The current limitation under Section 33, under Section 30 open brackets 3 close brackets, allows a registrar, this is important, it allows a registrar to refuse to register a name change if as a result of the change the name would become a prohibited name. Now, a prohibited name is defined by a range of different points. A, it's obscene or offensive. B, could not be practically established by repute or usage. I, because it's too long. 1, because it's too long. 2, because it consists of or includes symbols without phonetic significance. 3, for some other reason. C, includes or resembles an official title, rank, or D, is contrary to the public interest for some other reason. Now, presenting this legislation, as we've heard, that it's barring criminals from changing their names, and we've heard these quotes, quote, a convicted criminal cannot be prevented from changing his or her name at the moment. That's untrue. A criminal can be prevented from changing their name at the moment because the Act allows the registrar to refuse to register a name if it's not in the public interest. So while we support and acknowledge this legislation, I just wanted to temper the sense of discussion that's been taking place in the Chamber and the wider community, because there is a role for the registrar under the Act for some other reason, as was mentioned, or because it is contrary to the public interest. So the registrar can act on these matters. There is a mechanism for the government to be able to deny a criminal under Section 10, includes a Section 10 under Section 10 of the Crime Sentencing Procedures Act. So it seems to me that while this is relevant and important and it's necessary legislation, we should not unduly alarm people in the community because there are measures that this can be dealt with, but unfortunately it wasn't dealt with. And we haven't seen it dealt with effectively in the past. But it is not true to say that a convicted criminal cannot be prevented from changing his or her name, end quote. That is not true to say that in the current circumstances. Now, there are a number of reasons why restricted persons may apply to change their name that should be recognised and considered. These might include religious conversion, marriage, cultural reasons. They may themselves be victims seeking to avoid identification by an offender. They may be seeking to make a clean break with their past, or they may have undergone a gender transition. Under section 31D, the supervisory authority can give approval for the change of name only if satisfied that that change of name, quote, is in all the circumstances necessary or reasonable. And we support that, and that's a sensible and logical use of words. It is likely that such a change will make it more difficult, however, for inmates and former prisoners to change their name. That said, reasonable restrictions on name changes which might pose serious security risks or be offensive to the victims of crime are entirely appropriate and I support. The penalty that applies to a restricted person applying directly to the registrar is reasonable, but care, of course, must be taken to ensure that this does not result in the penalisation of innocent mistakes where a person does not know they have to apply to the supervising authority directly for a change of name. And I'd ask the Minister to address that issue in closing if I can. That, of course, the penalty that applies to the restricted person is reasonable, but what steps will the government be taking to ensure that people know that they have to apply to their supervising authority directly for a change of their name? So advice from the Minister on that would be appreciated. So in conclusion, Mr Temporary Chair, can I say that we support these measures? We encourage civilised and measured debate in the community about these matters, in particular when it comes to the criminal justice system. I congratulate the Attorney-General for the positive approach that he is taking towards crime and law and order for the most part, and we look forward to working with the government to make sure we have safer communities, more vibrant and positive communities. Thank you.
Question is that this bill be now agreed